The way that the court approaches every analysis of customary rules has an intimate relation with the way that they're solving controversies. It would seem that by having these two elements that we have mentioned in custom, it would be just as easy to grab them and fill boxes, so to speak. And if the boxes are full, we have custom. But indeed, we have to look at a bunch of things when analyzing custom. We have to look at the relation with treaties. We have to look at the relation with general principles of law. We have to study the way that states engage in a meaningful way with these other rules to ascertain whether we actually have a rule of law or if we only have practice or opinion juris by itself. So so far, we have these elements, and just to close this part, the court indeed sometimes gives more weight to one of the factors than to the other, and sometimes it draws conclusion just having the practice of states, and sometimes it actually finds custom by analyzing the beliefs of the state, the subjective element. But indeed, both elements and both parts of what constitutes custom are always in play. And in the end, the analysis, the work of the court is taking all these elements and making something out of their existence. So, having said that, we should take a pause here to understand that custom is very much like a path, a trail that's created by the constant practice of states. In the words of Antonio Machado, caminante no hay camino, se hace camino al andar. Walker, there is no trail, the trail is made by walking. The trail of custom is indeed created by states repeating a conduct a lot of times. And every act that the entities of international law undertook from the ancient times has come to us in one way or another to create the rules of international law. We have rules that existed, for example, in the law of the sea, that started when men, for the first time, built a boat and took to the seas. When we found out the way to trade the production of our village with the nearby village, we started to create rules for trade. When a general arrived with a letter signed by the Emperor of Rome, visiting the king of a province, asking for specific favors in representation of Rome, and the king protected this emissary of Rome as a special guest on virtue of these documents signed by the emperor, which was called the diploma. Diplomatic law was being created, and all these rules that come from to us from antiquity, and that are as old as humanity itself, are creating international law. So indeed, the path of custom is a path thread a lot of time by a lot of factors with very different weights, and each in their own way affects the creation of general rules. So to start our analysis, we turn to the North Sea continental shelf cases solved by the ICJ in 1969, in which the elements of what custom is were spelled out by the court, and which is one of the first bases that you would be wise to read as a source for study of what custom is. And indeed, two elements are identified in this case. Reading the obiter from the case, two conditions must be fulfilled. Not only must the acts concerned amount to a settled practice, but they must also be such or be carried out in such a way as to be evidence of a belief that this practice is rendered obligatory by the existence of a rule of law requiring it. Indeed, the court is actually in its dictum starting to tell us that we have two elements. And this analysis, in which the way that the Article 38 mentions custom actually splits it in two parts, because what we're looking for is a practice that is an evidence of the existence of a rule. But the practice itself is the evidence that at some moment there was a belief that this practice was compulsory. So the court doesn't hesitate in actually splitting this into two elements, in which we first must understand that there is a practice by states. So not only must the acts concerned amount to a settled practice. Let's dwell on this a little bit. We need a consistent practice by states. What is practice for the court in this sense? Well, practice are all those acts in which the states express their position related to an aspect of international law. What do we need right now? These are the footsteps on our imaginary trail. This is the evidence that the states are actually walking over this trail. Okay, so what can we look for? Well, first of all, administrative acts. And what do we understand by administrative acts? Well, any expression of the activity of the state that gives us element to understand that the state has a certain position will be a proof of state practice. It can be orders from an executive organ. It can be the positions stated in international organs by representatives of the state. It can be diplomatic communications amongst embassies of different states. It can be judicial activity, affirming certain practice based on international law. And in a more wide sense, treaties can be an important element to show evidence of state practice. How are treaties evidence of state practice? Well, the rules that states include in treaties are understood to be rules that bind only the state parties most of the time, and that the intention is to have this private recognition of a rule. Indeed, if we go back to Article 38 of the ICJ statute, you will see that the treaties, as mentioned in Article 38, to be considered as part of a resolution of a judicial conflict would be the treaties, whether general or particular, between the parties. And in fact, like in the first step, it is understood that treaties, most of the time, only create an obligation for the parties involved. But treaties can be used as evidence of the belief that there is a rule of law that is considered compulsory. And if this rule of custom is written down in a treaty and is being signed in a treaty by the parties, we could call this a process of crystallization, in which this rule, which used to be custom, is expressly written down and put down in writing to make it clear that the parties believe in it. And so it could happen that the rule that's found in the treaty indeed clarifies the fact that it's considered compulsory. But we have to be very careful understanding this interaction between treaties and custom, because treaties, due to their nature as an act of expression of the will of states, most of the time have a life separate from the process of customary international law. Treaties and, in fact, the clauses that the states agree on can actually also create custom by creating accords that deviate from the general rule of custom. But that's the whole point of looking at treaties as evidence. of state practice. Treaties can be used to prove the fact that a certain rule is considered compulsory by finding the same clause in several treaties. They can be a proof that that practice is being modified by the fact that states are signing clauses that go against the understood customary rule. And they could, in fact, create a new rule separate from the existing customary rule by repetition. So, generally speaking, treaties are an important part of understanding what the rules of custom are, as they are expressions of the will of states in a clear manner, or they can actually be evidence of the fact that a particular rule of custom is no longer being respected. But always, 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 we have to give the proper weight to these findings from the treaties. The treaties will be evidence. They won't be a proof, so to speak, of the existence or non-existence of general rule, apart from the treaty obligation of the particular nature of this treaty obligation, but rather we use them as evidence of something else. It's a little bit funny because Article 38 gives the same weight to treaties, to general principles of law, to rules of custom, but in fact there may be circumstances in which you are using a treaty to give elements to the existence of a norm of custom. But in that case, the treaty is being used just like that as evidence for the existence of a rule of custom, not properly as a separate source or a separate evidence of the existence of a norm. So, having said that, and having known what elements can be used as proof of the state practice, we have to ascertain some other factors which are related to characteristics of the practice that the court has taken into consideration for determining the existence of a rule of customary international law. And the first one is the passage of time. Many authors argue against the instant creation of a rule of custom. There are considerations that there must exist some kind of practice for a rule of custom to arise. The great academic Joram Dienstein used to say that the only instant that he had at hand was instant coffee, and that was because he was in a rush to teach. And after that, arriving at school, he could not talk about instant custom because custom would require some sort of effort in the international community. A single act or a couple of facts by a single country or a couple of countries wouldn't be enough to create a custom, because the requirement to have a consistent practice requires time. Once again, we need feet treading through the trail and creating the trail by walking once and again. And it is said that at some moment, the roads that we have now were paths that were walked by animals, and eventually people started following them. And then eventually we created 12-lane highways over the places where a single rabbit used to run to get away from predators. And indeed, that's the way the roads are created. Well, here, the passage of time is important because to establish the existence of a rule of custom, we need the constant test on the way of practice to ascertain that this conduct is considered compulsory. We have to have a lot of cases to know that there is a rule there. And so the passage of time, it could be argued that maybe in a short period of time, we can have a lot of manifestations that could create custom. But even then, maybe 5 years, 10 years, there's no time limit. But there has to be some passage of time. And this is an important requirement. In the end, to show that there is practice, some time must have passed with the states following this practice to create a rule of custom. We have to make another qualification here as to the creation of the norms, which has to do with the generality of the rule. Rules of custom are intended to bind states whether they want it or not, because a rule of custom will be desirable for the whole community. That's like the basic tenet of custom, and that's the reason for which you could remove will as an element of the creation of custom, which we will discuss in a few moments. Most of the time, you would understand that international law depends a lot on the will of states, and the creation of norms, as exemplified, for example, in treaties, has to do a lot with states accepting the creation of the rule. But indeed, in this process of acceptance and maybe the expression of a sort of will of the state, states will sometimes be bound to rules that they do not find convenient for themselves. But in some sort of international reciprocity and in the desire for order, states will end up accepting these rules or following them, even if we would say in Spanish, a regañadientes, if regretting the fact that they're compelled to do that. But indeed, states will create and participate in the creation of rules that bind them even against their convenience. And let's not say against their will, but rather their convenience. And this characteristic of generality is one that we must study when trying to ascertain a rule of customary international law. To this effect, the International Court of Justice has talked about the idea of specially affected states, because indeed, in the practice, the rules that have to be followed as rules of custom will be created by the practice of states that are relevant to that practice. And in this way, even if the process of creating a rule of custom by practice is egalitarian, somehow we have to weight the importance of the practice of some states more than others to create the rule. And this is a merely factual, practical consideration. Why is that? Well, the classical example has to do, for example, with the rules of law of the sea. The process of creation of the rules of the law of the sea ended in a series of conventions. And in fact, there were nations that did not want to participate due to their being landlocked. And it would be interesting to know, if we get into the study of international law of the sea, what's the difference between a state that's landlocked and a state that has the biggest fleet in the world when qualifying their practice regarding the law of the sea? Because indeed, even a landlocked state might have an opinion about how things have to be done. But the fact is that specially affected states, the ones that have to live with the rules created by the international community, their opinion must be weighted and their practice must be weighted in a special way in which we see how that position that they hold in the international arena affects the concrete application of the rule. And once again, the North Sea continental shelf cases were an excellent example of this, because they hinged on the fact that we have two competing arguments, one related to a convention, which was not signed by one of the parties to the case, and the other to a method that was purported to be custom by the other states. So the fact is, we had two clashing interpretations as to what the rule of law should be in analyzing the delimitation of a continental shelf. And in fact, the analysis of the court went to see what were the practices that the states in the region were undertaking, and trying to find out if the methods that were proposed the baselines and the equidistance method, which yielded very different results in the creation of the boundary lines around the continental shelf, had a basis in custom. And in that particular case, the court actually found out that the method that was being proposed did not have sustenance in custom, but it pointed out the fact that if you are to prove custom, it is very important to consider the specially affected states, which are the ones that in the end have to work with these rules. We would be very interested in finding out if this landlocked state has an opinion, for example, on sea lanes, but the fact is they will have an opinion, but the practice will not be as important. But maybe they actually own ships and extend flags to ships that have shipping lanes and that under treaties are shipping out of ports of other countries. And maybe in that case, if we have a landlocked state that has interests in maritime lanes and in maritime practice, maybe we are interested in their opinion. And that, once again, we analyze if their conditions affect the way that we have to make an interpretation of their position and their practice. This has come into play also in cases such as the advisory opinion regarding the use or threat of use of nuclear weapons, because in the end, the practice has to be analyzed not only related to the opinion of whether or not a rule operates, but the fact that there has to be a meaningful action behind the practice of states. And in that sense, we come to another element that has to be considered, which is uniformity and consistency of the practice. We need a series of facts that are intended to correspond to a general rule, but there has to be a uniformity of facts. Like all of these actions have to go to finding a pattern of conduct of states that is considered as compulsory. Not necessarily all the time, but the court in Nicaragua, in the Nicaragua case, gives a little leeway, and practice must be almost always consistent. Like not all the time, there may be deviations, but in fact, the practice has to have a sort of consistency. And if in fact deviations from the general practice are considered as deviations or as breaches, and if there is protest by the international community, and if there is some sort of repudiation of this attitude on behalf of the state that breaches the international order, indeed we have a reinforcement of the idea that we have a rule of custom. But so what is required of the international community is a consistent practice and more or less uniformity. We have to see that states, when facing a particular course of action, most of the time will react in the same way. If this reaction is consistent, if we have a uniformity of opinion as to whether the actions have to be this way, then we have more or less a uniform or consistent practice. So far, we have concentrated on the part of practice, which is most of the time material. It is built by the daily work of states, by the usual activities of the state, by their participation in international forums, in international organizations. But what we're looking is at the external attitudes of states. That leads us to what we call the subjective element or the psychological element of custom, which is called opinio juris. Opinio juris would quite simply mean the belief in the fact that something is legally compulsory. It is considered to be a subjective element, a belief, a psychological element, and well, it's a little bit funny to think in terms of having a psychological element. In the end, how are we to ascertain the belief, the thought of a state? Uh, I mean, states do not have an intelligible way of expressing their feelings. But indeed, the language that the court has used and the experts in the International Law Commission and many academics leads to these words, which seem a little bit funny in the context of international law, in which we're looking actually about this nebulous area of feelings, of understandings, of beliefs, as we had an article of faith in international law. But what does it mean in practice, and what are we expected as international lawyers to look for when trying to ascertain opinio juris? Well, we return to the North Sea continental shelf cases, in which we can read that two conditions must be fulfilled. Not only must the acts concerned amount to a sale practice, but they, and this is the second part, they must also be such or be carried out in such a way as to be evidence of a belief that this practice is rendered obligatory by the existence of a rule of law requiring it. So, this is the fun part. We already have an expression of the practice of states. We have states doing things. They write memos. They send each other diplomatic cables. They go to international fora and they state their position. Sometimes they order things within their countries that affect foreign nationals or foreign states. We have several ways in which states are actually showing off the position that they hold. But is this practice actually practical consideration, problem solving, or is it ascribed to the belief of the existence of a rule? Well, that's the whole point of the matter. To find out a rule of custom, we must not only have the practice, but we have to have some evidence that there is a belief that the practice is a manifestation of a rule of law. I always like to bring up this weird example from nature, which is that some migratory birds have paths that are not straight at all. So some birds, when migrating south in the winter, for example, will suddenly go in a straight line and at some moment make a round trajectory over a valley, for example, and then continue straight. And it's a very weird phenomenon that ornithologists study. And the working theory around this is the fact that at some moment in history, there was an obstacle in the path of the birds. Maybe there was a forest, maybe there was a mountain or a volcano or something like that, and the millenary life of the world has modified that terrain, but the path of the birds still considers that there is something in their path, and so without even knowing, they avoid this invisible obstacle because they consider the obstacle to still be there. Well, the opinio juris aspect of international law is a lot like this. States avoid an invisible wall because they consider that wall to be present and to be respected. And the expression of their practice, the path that they follow, might be an evidence of the belief that there is a wall on their way, so to speak. Opinio juris is a little bit complicated to show most of the time, because funny enough, the way to show it has to do a lot with the practice of the states. Like, this is funny. We have apparently two separate things that we have to prove with the same set of elements. But in fact, opinio juris is an expression uh, of this compulsory part, and it can be ascertained by actions other than the practical application or resolution of a situation. Practice must never be divested from the belief of this obligatory nature of the existence of a rule. Otherwise, it's empty. Like in the Lotus case, the Permanent Court of International Justice gave us some examples of actions in which states, for example, in the high seas, uh, practiced consistently, for example, flag salutes or some administrative things that happen among ships. But in fact, if you were to show how they operated in the terms of international law, there was no consequence to not carrying out this practice. And the practice devoid of consequence had no consequence, so to speak, or no reaction from states. So we had practice, but we didn't have that compelling element of opinio juris to show off the fact that we consider this to be legally legally obligatory. So it's funny to see that we have these elements of practice and belief, and they have to be ascertained in this very artisan feeling to understand whether we have a rule of law. And it's very funny that the word feeling is brought up once and again when talking about custom, because we do not have a real way of knowing the feelings of a state. I mean, we cannot ask a state, how are you feeling? What do you need? What do you want? But in fact, we have to study the practice and try to work out something from that. Here is a distinction I think that can be made to understand this in a more practical way. In particular acts of state, like the administrative, legislative, judicial acts of the state, represent a practice. And this practice is individual. That's the state practice, the practice of a single state. And we have the practice of several states, then we have a pattern. And then we have a pattern that corresponds to what we understand as state practice. Sometimes you find the name inveterata consuetudo. That's a very old continuous practice. But the pattern that is ascertained as a state practice is individual. It's a single state, and then we have to study all of the states that are doing the same thing. That's state practice. But on the other side, we have opinio juris. And opinio juris is not directed as understanding to the particular position of the state. State practice is what I do in following a rule, what I think is a rule. But I mean, there can be practice devoid of this belief of the existence of a rule. So what thing is a practice? Like the material thing. But the part of the opinio juris has to do with the state's position on whether there is a rule, and more specifically, a rule that should apply to the international community regarding what I practice at home. If I think that this norm is compelling and I practice it, we have practice. But if I feel that this rule is compelling and is obligatory because not only me, but all the states should follow it, then what I'm giving is evidence of the existence of opinio juris. And sometimes it can be an outright statement as saying, yes, I believe that there is a rule of law and that my attitude corresponds to law and that this legal rule compels me to do this. So in fact, some actions of the state can be shown to be evidence of practice that reflects belief, and it's very fun. The fact is, when ascertaining a rule of customary international law, you can use some elements either to prove opinio juris or state practice, but most of the time, if you're using it to prove one, you shouldn't use it to prove the other. Either you're showing a pattern of actions by a state that constitutes state practice by a state or states, or you're showing their belief on the compulsory nature of those actions, in which case we're talking about opinion duties. It's sometimes a little bit confusing, and the court does not adhere to the formula all of the time. And sometimes they pick and choose by convenience, and sometimes the same action can be used as evidence of either practice or opinion duties. But in fact, there is a very slight difference, and we have to be very careful when studying patterns of purported customary rules to see if what we have is a state practice or opinion duties. But going further, we can refer to the advisory opinion regarding legality of the threat or use of nuclear weapons, in which we have a very firm foothold on the ways in which we assert an opinion duties. The court referred to a very specific case, and this is very interesting as a staple of how opinion duties is asserted. General Assembly resolutions. Most of the time, we are told that the documents of the UN are not legally binding, which makes sense. Resolution of the General Assembly is a position. It's an opinion by the General Assembly stating we have a problem and it should be solved this way. And you can contrast it to the executive way in which the Security Council of the United Nations solves problems, in which, well, the Security Council resolutions order, invite, command, create organs, create missions. Well, the General Assembly observes, it's worried about, it's suggesting, it's inviting. So General Assembly resolutions are not legal documents or did not create these obligations by itself, but in the matter of customary international law, they're very interesting as expressions of the opinion duties of the states. Because indeed, in the General Assembly resolutions, most of the time, due to its generality and the way that the United Nations works, we have sometimes clear expressions of the beliefs of states. The General Assembly concerned with this problem, recognizing the principle of X, Y, and Z, and the resolution points it out. We recognize this principle. We consider that this principle has a place in international law. And so the way that these resolutions of the United Nations, even if prima facie they are not legally binding documents, they do not create obligations by themselves, they can show the belief of the international community in the existence of a rule of law. And in my point of view, this is amazing. We have the states actually agreeing on stating some rules and the building blocks for a more complex legal system. Indeed, the legality of threat or use of nuclear weapons advisory opinion refers to several resolutions, including the resolutions on friendly relations, which state a series of principles which the states, by consensus, consider to be the basis of international relations. So, funny enough, this non-legally binding document is actually an element for the understanding or for the determination of the existence of a rule of custom. And in the same sense, you have to know how to work with these kind of things when approaching Jessup, because this is one of the most common things that you will be asked to talk about, the value of a General Assembly resolution. You will hear that question at some moment if you are in Jessup. Why? Because the use of these documents and the use of the principles contained within are one of the most important building blocks of international law. But as with all your evidence related to sources of international law, you have to know where to use it and you have to understand why or how you're using it. So uh, we have two situations here. Either we have a resolution which clearly states that we have a rule of international law, of customary international law, or we have a series of resolutions in which we can see a pattern in which states are dancing around an invisible wall, which leads us to believe that there indeed is a rule of customary international law as recognized by the practice of the states and by their affirmations. So we have here the example, the particular example of General Assembly resolutions, but this analysis extends to other documents produced by states in their international engagements. And as a way of example, and being a non-restrictive list, we have well the General Assembly resolutions, but also the resolutions of other organs, of other international organs or organizations, because indeed international organizations can state their belief that there is a particular rule. It might happen. We have the International Law Commission and the documents that they produce, and it's very fun to see that the International Law Commission is actually a group of experts which are tasked to codify and to progressively develop international law. But a lot of times they act, and Mr. Alain Pelé calls them the little sister of the International Court of Justice, which I find a beautiful image. The International Law Commission indeed does a lot of things that the court finds cute and sometimes compelling, and that are very often used to a certain some circumstances of their interpretation of law. So, in fact, the International Law Commission had just presented one of their first readings of the articles on international responsibility, and a couple of months later, the document was still fresh from the oven. And in the Nicaragua case, the court goes and uses that document from the International Law Commission and starts using it as the basis for analysis of the case. So the International Law Commission actually does a lot of work on codification and on the determination of some rules to be custom, and they do the work, the academic work and the theoretical work, but they also do this progressive interpretation as to what is desired of international law. So the documents by the International Law Commission can be used as building blocks to find the pattern of opinio juris, but, and this is a practical recommendation for Jessup participants, if you are using a document by the ILC, you have to know whether it's being executed as codification or as progressive development. Because if it's being done as part of codification or study, then you have elements to use them as proof of opinio juris or the elements of the existence of the rule. But if it's progressive development, well, it's good hopes and a prayer that this should be the thing that states eventually will accept. So we could find elements of opinio juris in the ILC and their work in codification and recognition of customary rules. We can also find a pattern of opinio juris if we analyze codification from other sources rather than the ILC. We have regional legal consultation organs, for example, in the Organización de Estados Americanos, which also undertake projects of investigation as to rules of international law. And sometimes they may give elements as to the existence of a rule of custom and might represent opinio juris of regional groups. But also we have a very hard evidence, sometimes in treaties, of the belief in the existence of certain rules. And this is a bit of the process that we call crystallization, when states state, so to speak, a rule of international law and put it down in writing. So we have the certainty that they consider A, that there is a rule, a general rule, independent from the treaty, and B, they want it to be as clear as possible. So as it becomes compelling and obligatory between the parties that are signing the treaty. But in fact, this element of finding rules or special clauses or something within the treaties might show that states do consider that it's their obligation and that there is actually a rule of law. So these kinds of documents, once again, are evidence. We are talking about custom as this huge box, but it's a box full of a lot of trinkets. And out of all those trinkets, we have to ascertain whether they correspond to a norm, to this rule of custom, or whether they're only practice, or maybe they're only opinion duties. Because in the end, you have to have both. You can have the state practice without the belief that the practice is compulsory, and you cannot have the belief that there is a rule of law without the relevant practice. And once again, the court has been able to study examples of this, both of a rule that has no practice, no meaningful practice, a purported rule, and of the practice that has no compulsory nature. So we have to have the two elements, and we have to have a very strict analysis of the existence of both elements so that we actually know that we have a rule of customary international law. Otherwise, we do not. Like the classical example is with the nuclear weapons. There is purportedly a rule which would be that the use of nuclear weapons is illegal, and we contrapose it to rule of nuclear deterrence as a customary rule. But the thing is, the states that can actually practice, the especially affected states, are those that have nuclear weapons. They're the ones who can have a meaningful practice regarding to the use of the nuclear weapons or the decision not to use them. And so there are a bunch of states which say, well, the rule should be that there should be no legal use of nuclear weapons. But the states that believe that have the opinion duties, have no nuclear weapons to back up their practice. And the court pretty much said, well, nice as it could be, the only thing we have is the fact that the practice of the nuclear states, the fact that there is a practice by the nuclear states, is avoiding the creation of a rule based on the opinion duties of the non-nuclear states. It's paradoxical, but in the end, we have the two elements split into sides, and the fact that we don't join them and we don't have a consistent practice and an opinion duties avoids the creation of a norm.